So, so the format of my presentation today will be sort of twofold. One is diving into a lot of the executive orders briefly that we've been seeing. There's just so much uncertainty now. I wish I could give you what to do exactly and what not to do exactly, but there's a lot of unknowns. And then second, I'll go into just a brief overview of some of the updates for employers in California, particularly for 2025, to make sure that you're making the appropriate changes to your handbook and you have all the right posters and things like that, as well as practices in your workplace. So we'll jump in. So that's me, my email, and they'll be at the end of the presentation too. And I'm happy to share these slides as well. So if to the extent anybody wants them, I'll send them over to Joyce and Dawn and they can distribute them. So the executive orders, I'm sure we've all seen the headlines about, DEI ending, the only two gender executive order, things like that. By and large, these apply directly to federal contractors and federal employees. However, they have pretty wide sweeping, or could have wide sweeping implications for all employers across the country. So right now, actually yesterday, there was a lawsuit filed against the president and with respect to the anti-DEI order. It makes several arguments, but one is that it's unconstitutionally vague. So that is all to say that we don't really know how long these will be around or to what extent they'll be applied. So what does that mean for everybody else, right? I think what it means is you have to look back at the Supreme Court decision last year, the university case where students beat affirmative action essentially. And what that said is you can't use quotas or any sort of overt DEI policies which would require hiring people of a certain race, creed, or color. But you can still have diversity, equity, and inclusion initiatives. So DEI in and of itself is not illegal, but you cannot sort of single people out based on what they look like or where they come from. But that doesn't mean you can, if you wanted to have a diverse workplace, you can still go recruit at a historically black college or places where diverse people live, or you can still consider people's background and education and skill set in order to find a diverse workplace. So just because DEI has been in the crosshairs doesn't mean that it goes away entirely, but I would certainly look at your policies if you have DEI policies or other similar policies to make sure that they don't overtly say, we want to hire 27% people of color or, whatever it might be. I would get rid of all the direct quotas and insert more vague language saying, we want a diverse workplace. We have everybody, we have an inclusive workplace. We treat people equitably, things like that, to avoid any scrutiny. Like I said, if you're in California primarily, I don't see, certainly the local jurisdictions and local government, state government won't be coming after you. But it's possible that could be some federal attention that you don't want. So to the extent you don't have that attention now, it's a good time to take a look at your policies and make sure that they're vague in essence. And we'll just sort of continue to keep tabs on where these executive orders go and if they continue to broaden or if they're challenged and defeated. It's just there's so much happening right now that it's really hard to tell what the ultimate result will be. So there's your lawyer's answer on what to do about DEI. But like I said, I think the thing to do right now is to take a look at your policies and practices and make sure that they're broad and vague, but you don't have to get rid of DEI entirely. So some new legislation, this is primarily California. For this year, there was a ban on captive meetings. So basically what that means is you can't have meetings where employees are required to attend if you're discussing political or religious topics. So you'd be surprised. You'd think, well, who's discussing political and religious topics at work? You'd be surprised it happens more than you might think. So you can still talk about these things, but just make sure that that attendance remains voluntary, and you're not disciplining employees for not coming, marking them absent or things like that. It's just completely voluntary whether employees will or can attend. So some more slides on this. I won't really get into it in too much detail. You're happy to review the slides, and of course you can email me after if you have any specific questions about this. There is a penalty for requiring captive audience meetings. We'll see to the extent that holds up. That is also currently subject to a lawsuit, but for now, don't require people to attend religious or political meetings. Job postings. Your job posting recently, as you may already know, needs to have pay scales. So you need to have the listing of how much you're going to pay that person if the job could presumably ever be filled in California. So if you have a remote position, you still have to have a job posting if it's remotely possible that a California person could apply for and get that job. But now you can't require a driver's license unless that person has to drive for the job. And it doesn't matter if they have to have a car to get to work. That is not a reason to require a driver's license. So we're talking about delivery driver, they have to travel between different locations during work, that sort of thing. So to the extent your job postings require a driver's license, just take it out at this point, unless it's a driving job. Intersectionality. So what this means is people are protected based on their protected traits in California, race, gender, religion, things like that. But here, this sort of clarifies that people are also protected on the combination of two protected traits. So if I am a Black woman, I am protected on the combination of those things and those things individually. Makes sense, kind of a thing to me, but this statute clarifies that. So to the extent you have, or your anti-discrimination policies need to be updated to include that. So some examples from the EEOC here. So there's local enforcement now, goody. It's in California. Local jurisdictions can also enforce anti-discrimination laws and have even more stringent anti-discrimination laws than the state. So now it's important to understand what those municipalities are that have those anti-discrimination laws. And if you've even got remote employees there, if you've got an office there, you've got to up your policies for those specific locations to make sure that they comply with those specific municipalities' laws. For instance, if you've got employees in San Francisco, I would be particularly cognizant of that. I believe they have one that they're putting together right now that will go into the works that's more protective than California law. Crown Act amendments, more sort of amendments required to your anti-discrimination and anti-harassment policies. It amends the definition of race and protective hairstyles. So race is defined more broadly, and so is the definition of protective hairstyles, which you can't discriminate against someone for that. And they amended it. So a small change, but one that you should make to your anti-discrimination policies. There's the protective hairstyles new definition. New workers' compensation notice. So really all you need to know is go to the Cal Chamber and get an updated poster to throw in the break room. Make sure you've got the new one for 2025. It gives employees more options about, tells them that they can seek an attorney if they need advice on workers' compensation, and that they have more flexibility to choose a doctor to see for workers' comp injury. It's all laid out in the poster. Paid family leave, so another policy requirement that needs to be implemented or included in your employee handbook. You can no longer require employees to use accrued vacation before receiving paid family leave. Previously, you could require employees to use at least 2 weeks or use up to 2 weeks of vacation before they qualified for paid family leave. Now you can't do that. So they can qualify for paid family leave right away if they're out for a covered reason. Another new whistleblower posting. So basically this will come about in July. a new model list will come out that needs to be posted. So just keep an eye open for any headlines about this, and make sure that come July, you're on top of it and you have the new posting that when it comes out. So this is the biggest change this year, and it's incredibly confusing. Basically, it grants time off for victims of crimes, or people whose family member was a victim of a crime. And they can use, this is a protected leave, so you can't fire them for taking this time off. It covers a lot of different things, which I'll get into briefly. But they can use paid sick time or vacation time to be paid during this leave. And if you discriminate or retaliate against them for taking the leave, they have a cause of action against you. So crime is defined extremely broadly, as you can see there. A misdemeanor or felony, I mean literally anything. And family member is also extremely broad. As you'll see that at the end, a designated person. That is completely or almost completely all the way or up to the employee to designate a person that they believe they have a familial type relationship with. And if that person is a victim of a crime, they can have time off to help that person, presumably. So basically, it could be a wide range of people. And so there's your designated person, related by blood or association, equivalent of a family relationship. Not really sure what that means exactly, but it's pretty much up to the employee to say, my neighbor Bob has a familial type relationship, and he was the victim of a crime, so I'm going to take time off. There's ways to push back on that, but the law is slanted very heavily in favor of the employee on this one. So they don't even have to designate the person sort of in advance. They can designate it at the time they request the leave. Yeah, it's a little ridiculous, but it is the law that we are given. So you can only get one designated person, 12-month period. So that's, I guess, one little silver lining. You can't go down your street and say, everybody that was a victim of a crime is my new designated person in 1 year. So if you've got over 25 employees, you can't discriminate or retaliate against an employee who's taking this leave. Basically it just kind of goes into the causes of action they could have against you. But this is what the leave covers, right? So, trying to go get a temporary restraining order, to assist a family member to get medical attention or recover from injuries if they're subject to an act of violence. I sort of won't go through all of these, but there's a lot of them. And that could qualify for quote unquote crime that would be subject to this leave. There's more and more and more. And all right, so time off can be limited to 12 weeks. But basically they have a lot of leeway to show how much time they get off. And even the absence doesn't have to be scheduled. Obviously a crime can happen at any time, so they can take time off with very little to no notice. All right, so more things you can do. You can, if they're a victim of a crime, you don't necessarily have to give them leave. So for instance, if they have someone that's stalking them, they can be transferred or reassigned, change their work telephone, change their workstation, install locks, things like that. Basically, it doesn't mean that they're going to be off completely, but they could have other protections in place. But it's something you've got to work with the employee to figure out. So you're not sort of required to inquire as to their status as a victim of a crime. They have to tell you about it. So that's good. You don't have to sort of poke and prod. Or if you hear through the grapevine that someone's been a victim of a crime, you're not necessarily required to actively reach out to them. They would have to report it to you. So you have to inform employees of their rights in writing. So this is all to say, yeah, there's all these requirements, but what do I actually have to do? There are two things. One is I would recommend updating your handbook. So it covers all of these requirements. And come July, there will be a poster or a flyer that the DLSE puts out that sort of, it's like the paid family leave flyer or the pregnancy disability leave flyer that you give employees in that big stack of stuff on their first day. This would be another flyer that would be inserted into that stack. So it's not out yet, but it will come out in July 1st. So come that time, make sure you have that flyer and you insert it into the into that initial packet. But even still, I think it's worthwhile to update your handbook. Your handbook doesn't need to have all of these requirements. You don't need to have a 40-page policy on time off for victims of crimes, but it should be updated because the protections are broader than they used to be on this. So I would recommend doing that so you can make sure you're on the right side of this requirement. So this goes into the form, by July 1st, there'll be a form, and there'll be FAQs. They told us it would be before the end of the year of 2024. They still haven't put them out, so we're still waiting for those. So stay tuned, but there will be some changes on this, but still update your handbooks. Make sure you've got a new and improved policy on this. Minimum wage increases this year. State goes up to $16.50. However, there's 40 local ordinances that mandate more than $16.50. City of and County of LA is at $17.27. The winner, highest one, is West Hollywood at $19.65. So make sure, to the extent you have employees at the minimum wage, that they are at least $16.50, if not more, if they're in one of those 40 different locations that have an increased hourly wage. That link at the bottom of the slide there is the listing of all 40 of the different minimum wages. So as the minimum wage goes up, so does the exempt level test. So if you've got employees earning a salary of less than $68,640, that means they need to be hourly. So otherwise, you either pay them on an hourly basis and give them overtime and meal and rest breaks and all the things that non-exempt employees get, or give them a raise. So they federally it's less, it's $58,656, but the requirement stands that you need to pay them more than this. It's just one half of the test though. So just because someone earns over $68,640 a year doesn't mean they're automatically exempt. They need to pass what's called the duties test. And what that means is they need to be performing exempt level tasks over 50% of the time. So just because you have a administrative assistant who's earning over $70,000 doesn't mean that they are exempt. They need to be performing things that require independence and discretion. So if they have a list that requires, every Monday, I check in and do this. I, make meetings for my boss and I take notes during the meetings and I take her, I take her and call cabs when she needs to go play. If she's paid $70,000, it doesn't matter. She's not going to be exempt. She needs to be making policy level decisions, decisions without much oversight from superiors, ability to hire and fire. These are all things that are, what exempt level people do. And if they don't, you can pay them $1 million a year, but it still needs to be on an hourly basis. So if you have a couple people that are popping up in your head, like, oh, I don't know if they're properly salaried, then you can give me a call or shoot me an email and we can talk about it. But that's just a word to the wise to make sure that you are on the right side of it. And the problem with it is if someone's misclassified, where they should be paid hourly, that means that they're missing their meal period every day. They're missing their rest breaks every day. They're not being paid overtime, and they get all the penalties associated with that in California. So it's basically a one-way ticket to violating every wage and hour statute there is in California. So, unlikely to come up. Not everybody sues, but if they do, it could be a problem. Inside salespeople, there's a different test for inside sales folks. The regular rate of pay that they earn needs to be 1.5 times the minimum wage, so it's less than 2 times the minimum wage, which is the $68,000 number. But half of their comp must be payment of commissions, and they need to be earning commissions at a pretty regular pace, because this is a pay period by pay period analysis. So in one pay period, if they don't earn half their money through commissions, they could be hourly. The next pay period, if they earn more than half, they could be salaried. And it could flip-flop back and forth. So again, this is a really tough one to meet. A lot of people oversimplify it. So again, if you've got people popping up like, I don't know, make sure that you figure out if they're properly classified. So as the minimum wage goes up, so do all these other sort of premiums, split shift premiums, maintenance allowance, minimum pay for employees who have hand tools. If you've got an outside payroll service, they should be on top of all this stuff. So this is not something you need to go and dig up yourself, but maybe shoot an email over to your payroll company and say, hey, where are we at? I just want to make sure we made the appropriate adjustments this year. Computer software professionals, you guys probably don't have too many of these in your workforce, but another one that's often misunderstood. They need to be like high level computer science coders. Someone who's pulling reports and making spreadsheets and other things like that are not going to be exempt, no matter how much you pay them. And their exempt floor is a lot higher. It's 118,000. So they need to make over that amount in order to be exempt. And there's other sort of requirements there at the bottom for computer professionals, physician, surgeon requirements. None of those here. So there was a Prop 32 last year to raise the minimum wage to $18. And it failed by a very narrow margin, 0.8%. So thankfully, the minimum wage is where it is, but you can bet that every year there'll be one of these bills to increase it at a quicker rate. So look forward to the end of this year. There'll be another bill to probably increase the minimum wage to $20, if I had to guess. All right, some wage and hour stuff. Boot up time. So hourly employees need to be paid for boot up time. I mean, it seems insane, right? The amount of time it takes to turn on their computer and clock in. But there was a lawsuit against a large employer who had call center agents. And they basically, when they got to work, they had to turn on the computer and then click start. And that's when they clocked in. The court found that the time it took to boot up the computer was compensable. They should have been paid for that. So 2 minutes every day for 4 years, it adds up, and there's penalties associated with it. So if you've got employees that are, and this applies across the country, this is not just California. If you've got employees that have to boot up a computer before they log in, there's a couple options. One, you can, if your system allows them to type in the time that they start, just inform them, type in the time when you booted up your computer, not when the computer turned on and you were able to log in. Or if your system just allows them to clock in, you can add 2, 3, 4 minutes of time per day to account for the boot up time. It seems so silly, but there's been a lot of lawsuits on this. And if that person is no longer with you, you had to have waiting time penalties. So what those are in California is if you don't pay someone all of their wages before they quit, then they're owed 30 days of pay, up to 30 days of pay as a penalty. So, John Doe comes to you and says, hey, look, you didn't pay my boot up time. You owe me like $10.43 for the 8 minutes that I didn't work. But since I quit over 30 days ago and you didn't pay me that amount, you owe me like $6,000 for the waiting time penalty. So it's just, it's silly, but just pay the people the extra time and don't have to worry about it. More about how the court found that. And the Judge Marcia Berzon is like the most liberal anti-employer judge on the Ninth Circuit, and she wrote this opinion, which is no surprise on how it turned out. More on boot up time, but basically this reasoning applies to lots of other things, right? Nobody really here probably does this, but if you have a security check upon leaving the building, I've got a bunch of clients that have distribution centers. So, people, packaging things and shipping them out, and they do security checks to make sure they aren't stealing anything when they leave. That has to be on the clock or paid for. Tasks performed by clocking out, if you've got non-exempt people that have to lock up after they clock out or do other things, make sure that they're being paid for that. I don't think anybody here has protective gear or anything like that that people have to put on or take off, but that's compensable. And again, texting or emails while not clocked in. If you are texting non-exempt people when they're not clocked in about work things, that is arguably compensable time that they should be paid for. So make sure that, this happens every day, all day long, at, thousands and thousands of employers across the state, and it's not an issue, right? So if it becomes an issue, then there's not much of a defense to it, but the likelihood of it becoming an issue, probably pretty small, if I had to guess. I don't know how many, exactly. I just know the times I see it are when it's a problem. All right. So, try and avoid texting and talking with non-exempt employees off the clock. And if you want to be A plus on this, then say, hey, look, I know we had an email conversation late last night. I really needed some info from you. I'll make sure to add 20, 30 minutes to your pay stub so you can be compensated for that. Travel time, make sure that employees are paid if they're traveling for work. Non-exempt employees, if they're flying to a conference, the minute they leave their door to fly for a conference, they are being paid. So make sure that they are compensated if they're doing work-related travel. Things that, like I said, most times doesn't come up, but when it does come up, there's not much of an argument around it. Bonus true-ups. So these are things that my clients from 5 employees all the way up to 5,000 employees usually get wrong. So when you issue additional compensation to an employee, an hourly employee, that is over and above whatever their base hourly rate is, more often than not, it needs to be included in what their regular rate is. So things that need to be paid, the base hourly rate is, let's say, is $20 an hour for one non-exempt employee. That means that if that's all they're being paid, their overtime rate would be time and a half, so $30. If they miss a meal period, they need to get a meal period premium. That's 1 hour's pay at the regular rate. If they're only earning their base salary wage, that's $20. So that's easy, right? But as soon as you pay them a bonus, there's any sort of incentive pay, if they earn commissions, things like that, all of these need to be factored in to that regular rate. So say that employee, you give them an annual bonus of $1,000. And almost certainly that will need to be put in the regular rate. So that means you need to look back across the entire year and say, how many overtime hours did you get? How many meal period premiums did you get? Did you get any sick leave? Those are the big 3. And then you use a formula to apply that $1,000 across all those hours, and you issue a true-up payment at the end of the year. So their regular rate might be $20.43 because the calculation would apply back over the term of a year. And that means that their overtime rate needs to be time and a half of $20.43, not $20. So again, this is another one of those ticky-tack wage and hour laws in California that the person might only be underpaid if you don't issue the true-up payment by like $4 over the course of a year. But there's a penalty for not paying the regular rate. If they leave, then there's the waiting time penalties. Then there's an issue, the pay stub is technically inaccurate because it doesn't include the true-up payment. It's all these sort of ticky-tack penalties that need to be factored in when you're using this, when you're issuing any sort of additional compensation to employees. Again, your payroll companies should be well equipped to figure this out for you. Sometimes they don't even want to touch it because it can be so complicated. But say, hey, look, I'm giving an annual bonus to my non-exempt employees. I want to make sure that it's factored into the regular rate. Can you please help me with that? And they should be able to do it. But if you don't tell them, they're not gonna, no payroll company is gonna automatically offer to do that for you. Because they don't want to touch it with a 10-foot pole because it's so often improperly calculated. So if all you pay your non-exempt employees is the hourly rate, don't worry about it. But as soon as you pay them anything more than that, you have to be concerned about the regular rate and make sure that you're calculating it correctly. Non-competition, just touching on this briefly. California employers know that basically it's no, you can't have non-competes, but there was the big FTC hoopla last year about banning non-competes across the country. So the FTC voted to publish this rule banning non-competes, but it ain't over till it's over. And there was a big injunction issued against that FTC rule, and the Texas court got rid of it. So the non-compete world, and the reason I bring this up is it's always in flux, but to the extent you have employees outside of California, in most states, you can still have a non-compete. But if you've got employees in California and you've got a non-compete that wasn't entered into in conjunction with the sale of a business or anything like that, just a normal employee non-compete, make sure you get rid of it because it's not enforceable. And not only is it not enforceable, it could subject you to damages and civil penalties for even having it in an agreement with an employee. So again, if you've got questions on this, you can reach out to me. But one thing I do in all of my presentations, just to make them fun, is I have trivia that is non-legal because nobody likes legal trivia. So if first person to email me the name of that movie and the team that Benny the Jet played for at the end of the movie wins a prize. And it's good prizes. Like a bottle of wine. If you don't drink, I'll send you something else. But I like to send people Santa Barbara wine as prizes. So you can email me the name of the movie and the team that Benny the Jet plays for at the end of the movie. First person to do that gets a prize. And of course, you can email me with other questions, much more boring legal questions. But thank you for having me today. I always appreciate speaking to you guys and girls. And thanks again. And if you got any questions, feel free to reach out.